afternoon. I'm Jessica Berg, one of the co-deans here at the School of Law, and Michael Sharp is also joining us. It is my privilege to welcome you to the 2021 Melman Lecture in Health Law and introduce Maxwell J. Melman, the Arthur E. Petersilge Professor of Law. Max joined the university in 1984 and in 1987 became the director of the Law Medicine Center, following Ali Schroeder, who founded the center. He received his JD from Yale and holds 2 bachelor's degrees, one from Reed College and the other from Oxford, which he attended as a Rhodes Scholar. Prior to joining the faculty, he practiced law with Arnold and Porter in Washington, D.C., where he specialized in federal regulation of healthcare and medical technology. Professor Melman is the author of 18 books and over 90 articles and chapters, and in 2013 he was named a Distinguished University Professor, which is the university's highest honor. Max's extraordinary work here at Case Western Reserve University prompted the generous anonymous donation by the family of an alum of the class of 1998, establishing this named lecture series in health law. The series allows us to bring in high-profile speakers in health law, all of whom are graduates of our school. And I'd like to take just a moment to thank the donor who enabled this lecture series. So it is my great honor now to present to you Professor Melman, who will introduce the phenomenal speakers for today's Melman Lecture.
Thank you, Jessica, and thanks again to the donors who've made this lecture possible, and welcome all of you. It's my pleasure to introduce our speakers today. David J. Elk is a 1961 graduate of Case Western Reserve University and a 1964 graduate of the law school. He is senior partner at Elk & Elk in Cleveland, Ohio, the firm that he founded in 1984 with his brother Art. The firm now has over 15 offices in Ohio and 1 in Seattle. Led by Dave's brother Art, the firm became known not only for its legal prowess and successes on behalf of its clients, but also for its marketing originality and prowess. In 2018, Craden's Cleveland Business reported that the firm had represented over 20,000 clients and recovered over $1 billion for them. Family is central to both Dave and his firm. His wife Marilyn is the chief financial officer for the firm, and Dave regards their relationship as the most important accomplishment of his life. Dave's daughter is one of the firm's attorneys, and Art's wife also works there. Dave says that when I go to the office, it's not like going to work. Our second speaker, James Kelly III, received his JD from the University of Akron in 1993. He practiced as a defense lawyer with Reminger & Reminger in Cleveland, and then joined Elk & Elk in 2002 and became managing partner in 2017. Jay has won numerous accolades and awards. He was appointed liaison lead counsel on behalf of the claimants in the fertility clinic event that is the subject of his and Dave's presentation today, entitled Cleveland, Ohio Embryo Litigation, a focus on unique legal issues, structural challenges, and resolution platforms. For those of you who are participating remotely and would like to get CLE, there will be a CLE code posted in chat. After the talk, we'll take questions and answers, and so please join me in welcoming Dave and Jay.
Wow, I didn't know we had that many offices. Welcome, everybody. Good afternoon. It is truly my honor, and I'm so grateful to be here, to be able to speak to you today at the and deliver part of the Distinguished Melman Award Lecture. As Mr. Melman indicated to you, I'm senior partner at Elk & Elk. I was born and raised in the Cleveland area. Marilyn's family and my family have each family has more than 100 years in around Cleveland. I've been blessed to be married to Marilyn, who is not just my true love, but my soulmate for 56 plus years, as many years as I've been practicing law. We have 3 wonderful daughters, Jennifer, who lives in New York. She's married to Victor. And they have an 18-year-old daughter, Celia, who is going to be graduating high school in next spring. My second daughter, Mindy, the middle one, is a lawyer in my firm, and she has 2 wonderful daughters. Meredith, 23, who's going to be married next year and is a loan officer in the Cleveland area. And Madison, who's going to graduate Kent State in spring. My youngest daughter, Stephanie, is married to Greg Garfinkel, who is a lawyer in the Cleveland area, and she has two amazing young children. Dylan, who's going to be 13 in the spring, and Sky, who is 8. I tell Marilyn all the time, and she teases me, I shouldn't. I tell her all the time, we are the luckiest parents and the luckiest grandparents in the world. It's a pleasure to be here with our managing partner of the firm, Jay Kelly, to talk to you about a high-profile case that had not just nationwide attention, but worldwide attention a few years ago. It involved what I believe to be the largest local number of people in a medical case with complicated issues.
Dave, sorry. It's on top of this, and so the image is accidentally hitting.
Oh, I'm sorry about that.
Put this down.
Thank you.
This.
Fantastic.
How's that?
Thank you so much. As Professor Melman indicated to you, when I graduated law school at Reserve, I went into practice both criminal law and civil negligence law. In 1984, my brother Art was a prosecutor. He was the prosecutor in Ashland County, right near Mansfield. And my practice was growing, and I asked Art about forming a partnership. So he and I did in 1984. And it was, in the beginning, just Art and I, and our two wives working at the office, Marilyn and Jody. As Professor Melman told you, we now have 21 lawyers with multiple offices and about 60 support staff. We truly have been blessed. And by the way, our wives still work at the office. Most cases settle out of court. Our attorneys are not afraid, however, to take big corporations and big insurance companies to the courtroom to duke it out if necessary. Most cases, as I indicated, settle, but when corporations have profits more than safety, and they consider that more than safety, families suffer the consequences, real consequences. And our attorneys have a passion to help people, to help injured people in this state and wherever. And we try to do that by serving Ohio injury victims of all types in civil cases. We're not only committed to serve the needs of our injury victims, but I truly believe, we provide a concierge type of legal service to clients by going above and beyond and trying to help them obtain the justice that they deserve. 3 things drive us at Elk & Elk: compassion, hard work, and honesty. And we believe seriously in all 3 of those things. We've always been committed to giving back to the community. And some of the organizations that we've assisted over the years, for the last 15 to 20 years, lawyers from my office and staff go to St. Augustine's Hunger Center the day before Thanksgiving. We disperse 200 turkeys, and my staff and our lawyers will help prepare meals for the needy the next day, Thanksgiving. We've been involved with the American Cancer Society, the Juvenile Diabetes Association, the Ronald McDonald House, the Cleveland Rape Crisis Center, the Boys and Girls Clubs of Cleveland. We've given away 200 turkeys for multiple years at University Hospital and Metro Health. And we've been longtime advocates of a high school program called None for Under 21. What it does is it teaches seniors the consequences of driving while under the influence or driving when they're distracted. We believe strongly in helping families to build a strong and active community, to make a positive influence on where we live and where we work. As attorneys and educators, we can and should help our city and our community to give, to grow, and to prosper. Just think about it for a minute. How lucky are we to live in a small to mid-sized city and have 3 world-class hospitals, Cleveland Clinic, University Hospital, and Metro Health. Add to that the Rock and Roll Hall of Fame, Natural History Museum, Science Museum, Cleveland Orchestra, the Metro Park system, which, by the way, was just voted the best in the nation, world-class colleges like Case Western Reserve University, Tri-C, Cleveland State, colleges close by, such as Akron University and Kent State University. What a great place to raise our family. We should all count our blessings that we live in the Cleveland metropolitan area. And as I tell Maryland, it's probably one of the best places to live, not in the nation, but in the world. I'd like to read to you something that talks about giving back. And I don't want to embarrass you, Mindy, but last Sunday, my daughter, Mindy, who works at the office, got an email from a client whose case she just recently settled. And I want to read it to you word for word. Thank you for the update, Mindy. You are the best. I will tell anyone if they're looking for a lawyer to call you. You are an awesome lawyer. You stuck to your guns, and I respect that a lot. God will bless you 20-fold. Thank you so much for getting that amount. I still have problems with my back. It stops me from doing the things I want to do. God sent me to you because he knew you would win for me. You truly are a godsend. Please thank everyone else who worked on my case. I'm very grateful. Take care. May God's love shine down on your firm and everyone in it. Thank you again, Steve. When I read that email, I just, tears came to my eyes. I mean, it was a wonderful email, and that's what we do. When people are injured, we can't change what happened to them. We can't make them well again, although in our 3 wonderful medical institutions they can try, but we can try to help make their life substantially better than it was, or than it would be without us helping them. I was told this lecture was to be about health law, and I believe you are in for an eye-opener because you will hear from the managing partner of our firm, Jay Kelly, who was appointed by the court to be lead counsel in the case, the high-profile case I spoke to you earlier about. It's the case involving the lost embryos and eggs at the cryogenic tanks at University Hospital a few years ago that were accidentally destroyed. Jay will explain to you some of the complicated issues. What laws apply to a lost egg to a family? What laws apply for a lost embryo to a family? Obviously, there are some confidentiality issues that we will, of course, adhere to, but Jay's going to explain to you the process. We were just so fortunate at Elk and Elk to represent more than 65 families of those people who lost eggs and embryos, to try to obtain justice for them that they deserved. Jay will explain to you how he was chosen as head counsel by the court, and he's going to tell you about some of the issues that came up in the handling of those cases that you can't imagine. We have here today the best person able to explain to you how some of those issues were handled. Without further ado, Jay, I turn the floor over to you.
Can everybody hear me okay? If I tend to wander a little bit, so I apologize if I get a little bit away from the microphone. And I'm guessing that to forward, I can just hit the button. So obviously,
we are recording, so if you can try to be by the
stay as
microphone,
close as I can.
that would be great.
I will do my very, very best.
Thanks.
So, as Dave said, my name is Jay Kelly. I'm at my core nothing more than a trial attorney. And as I tell everybody, good facts make great cases, and good facts make great lawyers, you know, in the jury's eyes at least. The reality of the case we're going to talk about today is I actually think it was my favorite case I've ever worked on. And it's because of how interesting it was. It's not because of a specific fact, we're not going to discuss facts, but it's because of the uniqueness of the case, some of the timing issues, and I can't tell you how excited I am that as I sat down, the person who was on the other side of the case against me walked in to the back of the room, and I use the word against figuratively, because I think one of the mistakes we all make as lawyers, as we view the lawyer on the other side as our opponent, instead of honestly somebody who is in the case with us. And in this case, you're going to see how actually there was more collegiality probably in this case and professionalism in this case, which is why most of you don't know many of the things about this case, because we let it stay private for the families and for all the parties involved. I was asked to take one sidestep before we start, and that is because obviously I am not a Case Western Reserve graduate. So we needed Dave to get me in the door because that is a requirement for speaking at this prestigious conference. But my career stands on the shoulders of Dave. And obviously, when you think about it, our firm was founded in this building because Dave started here and we started with Dave. And when you have a problem in our office, you go to Dave. Dave's where you collaborate, Dave's where you get advice, and Dave's where you go to, honestly, when a client just won't listen. So one of the things we thought of, how do we celebrate Dave and Case Western Reserve? So one of the things, Dave, you do not know this is coming, but here it comes. You're going to hear tonight that the classroom across the hall, which is their collaborative classroom, is now going to be the David J. Elk classroom going forward. It is, if you knew Dave more than, and you got a good look into his soul in his intro, describing his soulmate. By the way, I like my wife too. I won't let her work at the office though. And bad news, I've got a couple of daughters in law school. I won't let them come either. So, but that's a different story. But a classroom that's active and a classroom that's engaging and a classroom where people bring ideas together and where people grow as lawyers should be named after you. Because honestly, every single person in our office has grown because of you. So it's a gesture from us to you. The students here, the more they get to know you, the more they'll realize how fitting it is. The only bad thing I'm going to tell you, Dave, there's technology in the room. And as you guys could all tell by Dave fumbling and advancing the slides, technology is not really where Dave belongs. So I think he still writes on a yellow legal pad. So Dave, we're honored to do something in your tribute to all you've done for us, and we look forward to you continuing to do stuff for us going forward. Just don't think because you got a classroom, you're done. I expect to see you at work on Monday. But you have tomorrow off. So let's get to the case, and I'll see if I can figure it out. So I said it's a great legal case. And I feel a little bad saying something's a great legal case because different for me, and Rita obviously has a different perspective. We actually meet the people behind the cases. And the people behind the cases, I will tell you on their side, were some people who built their entire careers trying to build an area of medicine that had never been developed. For us, what had happened was we had 950 potential plaintiffs. About 400 to 500 came forward at the end of the day. Where I was completely ignorant was I had no idea what people went through. I had no idea how different everybody's story was. And I had absolutely no understanding how this impacted people. It's something that we know exists. It's something that if you haven't gone through it, if it hasn't touched your family, you have some understanding of it. But when you sit in front of somebody and you hear that they have done 16 or 20 attempts before IVF and had multiple failed IVF attempts, and that they finally felt like they had control, you start to realize how important it is. So the first box for both sides, it was incredibly relevant, issue and damage. The next thing when we look at a case is it's a first impression. There had not been another case of this size or structure, and most of what is an embryo hadn't been decided in the state of Ohio. One of the cases we may talk about during this brief lecture is someone tried to file a wrongful death case on behalf of one of the embryos, ultimately lost, but no one knew. What is the value of is an egg and an embryo the same? Obviously an embryo is a fertilized egg, but are they the same? What's worth more than the other? How are they different? So these are not things that have been legally pioneered or that ground had not been plowed. The unique challenges. So most of you are about to become lawyers, and I will tell you, take great confidence in the fact that if I can stand here as a lawyer, you're going to be fantastic in this business. The reality, though, is every lawyer has ideas, every lawyer has egos. On my side, I will say that my side was harder than Rita's because I had 86 friends who all represented other plaintiffs. And so I had 86 cooks, 86 egos, 86 ideas beyond my own that we had to account for. And the real challenge was, how do we get those people to a point where the 86 ideas don't detract from each other, but they actually enhance every individual's person's claim? And it was a challenge. There's no doubt there's incredible talent. People sometimes ask, why me as liaison counsel? The role of liaison counsel, so you know, I was the individual tasked to speak with the defense firm and the court. The idea was that everything would filter through me for all of the clients. I joke, but I think it might be partially true. The reality is I was one of several people qualified, and I think if there was a vote, I would have been everybody's second choice after themselves. So I think I would have won on the second place ballot because everyone would have voted for themselves. But the reality where there were several people who could have, filled the position probably as well or better. And next, societal interest. It was on the news, and I'm going to talk to you a little bit about how that impacted the plaintiffs, because that was, to me, probably the saddest consequence of this case, was that all of these individuals watched the most private thing in their lives become publicly litigated. And every news story, in my personal opinion, was worse than the one before. So, because they were a little bit misleading. So as we jump into it, I am not going to speak, so you guys know, about any fact that's not in the public record. The reality of the case is, for both the plaintiffs and the defense, there's confidentiality agreements, and things were exchanged under what we call protective orders. So we're going to continue as we have the whole way to honor that. So the lecture is going to go more focused on how did we set up the structure, what legal issues did we have. Rita's going to get to see some of our bad ideas today and tell us why we would have been wrong if we went a different way. But we're going to kind of go through that way, focusing on what laws apply or don't apply, how are we going to do discovery, how are we going to ultimately resolve this, and then kind of a little overview at the end. So when we look, this goes back to March of 2018. And so this happens the weekend of March 5th, 2018. And I will tell you within 48 hours, there were already lawsuits filed. And, so it was a race proverbially to the courthouse. But what we found was the temperature in a cryogenic tank, which is just a tank that holds in these straws the eggs and the embryos, fell. It fell to a point, or actually raised, to a point where the eggs and embryos were no longer viable. So they were lost. There were approximately 950 people's eggs or embryos in the tank, and 4,500 total, of those in there. I will tell you, when the case first came in and we began processing the issues, we asked ourselves, is this a class action? Or is this something where it should be a consolidated action? Or should it be something different? Class and consolidation became the big argument. A class action, we do not believe applied. It didn't apply because everybody's damages were unique. While yes, the same mechanism of injury caused this loss, it did not apply equally to everybody. So there would not be a fair, equitable remedy in class, we did not feel. And ultimately, even though I think 7 class actions at least were filed, all of those in the Cuyahoga County litigation ultimately passed, and we moved towards a consolidated litigation. A consolidated litigation became a local version of what we call a multi-district litigation or a mass tort. And so what happened was, every case that got filed got reassigned, initially to Judge Stuart Friedman, and then ultimately to Judge Ashley Kilbane, who replaced him. So we had a brand new judge in Cuyahoga County who literally got elected and walked into the middle of the Embryo litigation, and I will say and I believe the defense agrees, and I can speak for the plaintiff and the plaintiffs I represented, she was honestly an incredible resource to the processing of the case. Sometimes we have an impression that someone isn't experienced enough or isn't going to be the right person, and we could not have gotten a better, judge assigned for us. So the consolidation, what happened is everybody filed, in essence, one of their cases, and it got you a place in the pool. And those cases all got moved, and then we had to come up as plaintiffs with a structure of how are we going to do it. The top became me as a liaison counsel. My job was meetings with all the plaintiffs' lawyers, delegating tasks to different committees that we had. We had a discovery committee, we had a science committee, we had, legal briefing and writing, who you're going to see a lot of their work here coming up. And then we would try to consolidate all of that, organize it, and then speak for the group. Most people, not all, most of us only filed one of our cases at a time because you were trying, for lack of a better term, to not overwhelm the court system. But we sat and faced all sorts of issues. We kind of touched on this. The argument for pro class, 950, common mechanism, different injuries. But we kind of, when we sat down as a group, came to this feeling. And what the heck is this case? What is it? Is it a medical malpractice case? I can tell you the defense would argue 100% yes. Is it a breach of contract case? Is it a bailment case? Is it a straight negligence case? What is this case? And what was shocking was we had a different statute of limitations for every cause of action. Some as long as 6 years, some as short as 1. Is this a product liability case? We have different evidentiary standards for certain ones. Is it general negligence to allow the temperature to rise? And this became, from the plaintiff's side, I think the single largest fight that we engaged in what is this case, what is this cause of action? So we kind of felt like we had all of these different roads and no answer, because there was not any sort of clear precedent within the state of Ohio. So the legal issues presented: breach of contract, bailment, promissory estoppel, negligence/gross negligence, breach of fiduciary duty, intentional infliction of emotional distress, negligent infliction of emotional distress, medical negligence. So we looked at all of those and had to come up with what applies. And remember, we represent approximately 400 people who came forward with lawyers and 500 who had not. So we have another overarching ethical argument. What is our duty, in particular mine as a liaison counsel, to the people who have not yet come forward but are within statute? If my role is to speak for everyone, do I have a duty to speak for those who haven't come forward but have a right? So that brought in our ethical kind of quandary for the case. So looking through, we'll look at each of them, and I'll kind of go somewhat quickly, because what is my time for ending? I don't want to, I'm a strict follower of never going over time.
Well, if we can have time for Q&A, we should be, everything should be done by 5:30, I think.
Okay, we'll be easy. Q&A done at 5:30 also?
Yeah.
Perfect.
5:20, no. Do you want the event to end at 5:30?
I thought it was 5:30.
Yeah, as long as the Q&A finishes at 5:30, that's fine.
We will do it. I was once a student. I have 2 kids in this room. I'm not keeping anyone over time. No one likes that in a building. So with breach of contract, what's the nice thing? It avoids tort reform and damage caps. So for those of you who don't know, in Ohio, medical claims have damage caps. And those damage caps are arguably $250,000 to $500,000. They can fall somewhere in between as well. We'll talk about that when we get to the medical claim. But Breach of contract doesn't have those caps. It has the longest statute of limitations. We as plaintiff lawyers love that. Give us more time for more people to come forward. And there's significant damages available within it. The challenge is punitive damages are gone. And punitive damages were something that we thought as plaintiffs, we needed, at least from a negotiating standpoint, to be able to discuss in the case. Would we win them or wouldn't we win them? No one knows. But we felt like we had a credible argument to make it. So we did not want to give it up. Bailment, for those of you, I think most of you have taken contracts, I assume, no different than a coat check. We hand off something of value. We expect to get it back. Bailment became the argument that the plaintiff's lawyers liked the best. The argument of bailment was within our room, number one of what people wanted to pursue. And the reason, because there were damages available. We thought it was a clean example of something was delivered, something was being held, damage caps would not apply. We could also make the argument on what is the value of the bailed good. And with it being a unique property, we thought we could make an argument that it could be whatever we wanted it to be, or that a jury could decide. So we thought this would get us around damage caps, and this would provide us the greatest amount of remedies available. So our intention as a group was ultimately that we were going to push for this to be a bailment claim. It did not come to that, but we will share that as we go. Promissory estoppel, this is just reliance on an expectation. We weren't big fans of this one. We didn't think it got us anywhere that was compelling. And when you look at it, when you look at the cons, it's very difficult to establish the elements of a contract in this setting. So gross negligence and general negligence, the big pro, punitive damages are available. Another pro, we don't require some of the costs associated with proving a medical claim. General negligence doesn't have the same expert requirements. So we wanted to spend some of our time looking at, could we get this here? The bad news is we're still going to have damage caps. Now, under general negligence in Ohio, there's an exception for high damage caps. So we at least had an argument there that we could get around the upper tier of the cap. But ultimately, we all had a fear that it happened in a hospital. If we lived in the general negligence world, we get moved to the medical negligence world. Breach of fiduciary duty gives us emotional distress damages, punitive damages, but statutory caps would apply. So that was one of our biggest fears. Intentional infliction of emotional distress, I hate it as a cause of action. I think if you're studying it towards, you're wasting too much time because you're never going to file the claim. But we did have some problems with it because we not only had to prove the wrongdoing, but also the damages. So this did not get as much traction. And this was, I would think, where the defense was definitely going to drive the case towards. And this is where we thought was our biggest risk in the case, is that we would end up in a medical malpractice circumstance. So you understand medical malpractice requires the three elements. A deviation from the standard of care, meaning if they were unreasonable in the storage of these embryos and or monitoring. We thought we would meet that. That breach was a clear proximate cause. We knew we would meet that. And then obviously the damages. In this case though, with an embryo and eggs, this is where some of the questions begin. One of the exemptions to the damage caps in Ohio is the loss of a bodily organ or the function of an organ. If someone is unable to go back and reproduce eggs and embryos, does that get us the upper tier of damages? Does that take us from the 250 to the 500? And then next, does that take the spouse to the 500 as well? So those became questions within the med mal of, can we get to the upper tier of caps? Does this person who did not have a functioning reproductive system, but medically we created a mechanism, and now that mechanism is gone, do they need that? So that became one of the things that we started to look at. If someone could go back through the process, what if they didn't want to go? You can't compel somebody to go back through the process. Does that make them irreplaceable? Is that a loss of an organ system? There's arguments to both sides. And then I will tell you, initially, when the case first came in, we're all like, oh, the embryo cases will have a value. The egg is a different value. We started to realize what really drove the value is what was in storage and what were your options. And we found that most of the people who had eggs in storage were individuals who were about to undergo chemotherapy and things like that. So going back through wasn't an option. So they suddenly became irreplaceable. So with med-mal, we were terrified, though, not only of the caps, but of the 1-year statute of limitations. You have a 1-year statute of limitations, and that goes fast. So that was one of our concerns. And in our fights internally, if I took you into one of our meetings, as people wanted to make the argument, this is a bailment, the counter was, well, if you don't file it as a medical malpractice case before 1 year, and the judge decides we're wrong, we're done. And we're time barred, and it's now a legal malpractice case. So probably an easier case. So ultimately, they did do the consolidated action. And that consolidated action in Cuyahoga County, I will tell you, was, in my opinion, and I welcome the people from Tucker Ellis to share theirs, even if it's different. I honestly think it was one of the best moments of lawyering in Cuyahoga County, because it was so far beyond professional by parties and counsel and the court that it created a very efficient structure. Because one of the things that we've all joked about and we've all heard in movies is the biological clock is ticking. Well, much more important to me than the statute of limitations was the real life limitations that my clients all faced, which is if they're going to go back into this process, with every day, week, month, or year that passes, their chance of getting put back in the same place successfully diminishes. So how can we find a mechanism of justice that's fair, that also gives them the opportunity to go back in? Now, the hospital did some nice things in that process. And, they sent letters, and those letters were public. They offered that people could come back, and they would do it. So they gave that option for people in litigation. But it's a lot to ask someone in the middle of a litigation when something has gone wrong to jump right back in as well. So I believe the greatest thing that we all did was, instead of focusing on winning and losing the lawsuit, we focused on finding a fair common ground that allowed the defense to move on and the plaintiffs to move forward. And for myself, I will tell you, my time as liaison counsel ended in just over a year, because I was able to resolve all of my cases. And I think ultimately you'll see, I think 99% of the cases were resolved within 2 years. Going forward, this is just the court's order, appointing. So I started touching on the pros of the consolidation. If you wipe the entire slide and focus on one thing, it's those families. The single biggest benefactors of the pros of the consolidation were the families. And I will tell you, I initially filed a brief in opposition to the consolidation, because my initial thought was, for my clients, I feared that the consolidation would slow things down. I was 100% incorrect, but that was my fear initially, was that I would get into some sort of lawyer chest pounding, battle. But it really did also reduce the cost burden. So some of the things that we shared was we ended up having 13 firms that were all on the executive committee. Everyone put in an equal share of case expenses. We then divvied up finding experts together and started finding, how do we price things? How do we price the cost of surrogacy? I had never thought of this. Like, how do you legally contract for a surrogate? How do you price for a surrogate in the future? How do you price for future components, whether it be eggs or sperm? And when we started talking to you earlier about some of those uniquenesses, what if you have 2 children with 1 egg donor or 1 sperm donor, but those donors aren't available any longer? So you would have had 2 or 3 eggs, no guarantee those were going to become babies, but now you won't have the same biological makeup of your children, which was important to some people. We had some couples where, the 2 men, they wanted a common surrogate and a common, egg donor, so that the egg became what connected the children, and that egg donor wasn't available any longer. There are fascinating stories, and I will tell you, every one of them was honestly nothing more than a tribute to perseverance for these people who got there. So the consolidation cons, I will tell you, was you couldn't move your case individually through the litigation system. You could move your case with the defense, you could approach the defense and discuss any of your cases you wanted, but you couldn't move your case individually. So ultimately we had 1 judge who was going to try the first case. And we had 400 people and 86 egos that all wanted their case to go first. And there was a reason he wanted to go first. We knew for sure the first person would be allowed to get punitive damages. With the second, I think they would tell me no. I would tell them yes. But the practical reality was we couldn't tell anyone for sure. So the first plaintiff was going to be in the unique position of being able to most assuredly pursue punitive damages, whether they met that burden or not. And to me, that was one of the largest consolidation cons, was at some point in time, there were going to be different remedies available for plaintiff 1 than plaintiff 2 through whatever the final number was. Sounds a little bit like Squid Games there, as I start to assign numbers to people. But the practical reality is that individual case movement became the biggest challenge. So the other thing was, it was unwielding. We had personalities. We had people who did things outside of our group. At one point, we had someone file a case in federal court, and it caused more angst in my life than probably the defense's life when we look at it, because all of a sudden, if you have a state question in federal court that's unresolved, you don't certify it to the local Court of Appeals. You certify that to the Supreme Court of Ohio. For those of you who have not studied Ohio politics, the Supreme Court of Ohio is not the most favorable bench for plaintiff rulings. So this was a mechanism to potentially skip the local Court of Appeals. And we were working as hard as we could to make sure that any issues we created would never be a Supreme Court issue. We wanted everything to be resolved as best we could as non-Supreme Court issues, so that we could never have to get there. So it gave a portal, almost like, a leaker of sorts. Those 2 outside actions, one went to Judge Oliver, there was another one filed in Geauga County, and I think Geauga County still has activity going on in it, but I've blocked that out of my life since I'm no longer in the case. But the practical reality is those outside actions, they were driven by quests for control, quests to change tempo, and I think an honest and sincere belief by those attorneys to move their clients to the front of a line instead of risking not being the first case chosen. So I think there were good, honest, and sincere reasons for it. I think there were also things that were counter to the group as a whole, but those were challenges that we faced, that ultimately did not impact Cuyahoga County when push came to shove, but they continue in some level to exist out there. Legal maneuvers. If any of you watched the news, there was no shortage of coverage. There were lawyers at funerals. There were phrases that were said and things like that added emotion. And for some of those individuals and some of those families, they 100% wanted it, and they probably deserved it. But the problem was, for those who didn't want it, they did not deserve it. So the news every night would have a different person's story, and they were obviously compelling and sad, but they generated a lot of emotion. Based on some people's comments, the defense was able to seek a protective order from the court and a gag order that eliminated public speaking on the case. The nice thing was, it also allowed the quick exchange of documentation through a protective order, so we could get the materials, but then the materials couldn't be shared. So the nice thing was, I think, for the defense, and they can tell me, of course, if I'm wrong, it gave them the ability to sit on some of the noise surrounding the case and some of the animus that was being generated from the case. And it turned out to be, for us, a little bit of a blessing as well, because the defense could not pursue some of the motions I suspected they would have liked, because it would have likely undone the gag order. Once a dispositive motion was filed on what is this and what is the cause of action, it most likely would have lifted the protective order. So the reality was, the gag order, I think, served an incredible benefit to the resolution of these cases in a peaceful and professional, manner ultimately. We may not have liked it when it first came in, but I think sometimes you realize after the fact things turned out well for you. So the statute of limitations was a huge thing. And as I said earlier, we're battling this 1-year statute of limitations for a medical malpractice case. I had a fear that the judge would declare these to be medical malpractice cases. So it's something that I was very, very worried about. The nice thing was, and it's something that was in the public record, we actually reached, to my knowledge, probably one of the first agreements I've seen. We've moved statutes on individual cases, but we were able to negotiate with the defense a 1-year extension of the med mal statute of limitations. So even for those individuals who did not come forward or did not have a lawyer. By doing that, it actually created a window of time where the gag order or protective order, combined with the extension of the statute of limitations, gave a perfect window of time for people to sit down and talk about what was best for them individually within these cases. And so ultimately we did it in public, in the courtroom. We did a joint motion for an extension of the statute of limitations to line the med mal up with, the statute of limitations for for product liability. Because we thought that was going to be the most, no one was going to go beyond 2 years. So when I talk to you about the sides working together, we fought and we argued and we told each other how we were wrong, or the other was wrong at least. But the practical reality was everybody was willing to sit down and come to things that allowed the case to proceed in this efficient manner. So we touched on that. So I want to talk to you a little bit, resolution. And obviously we won't talk numbers, we won't talk anything of that sort. But what really started to drive the resolution were what we were calling individual lawyers' inventories, meaning your collection of cases. And for myself personally, every case was an individual case. And what you started to look at is, how do we put that person back in the same place? Can we put the person back? So was this a replaceable or irreplaceable plaintiff? And if they're replaceable, what step or steps do they have to go through? So, for instance, if you were 31 and healthy, unexplained infertility, but you were now 33, you were in the same risk pool, so you could go back. So that was one level. The other level was you were a cancer patient who had no children, had no eggs. In between were people who had a couple of children, weren't sure if they wanted more, but wanted that autonomy and control. And I will tell you the word that we heard in our room for every one of our plaintiffs was autonomy. Was they felt like the loss of the embryos was a loss of control, of something they sought control, some for 10, 15 years, and losing those was as if they lost that control all over again. So that was the structure of it. And for me, my focus was how do I do it fast to maximize my client's options? And fortunately, and every resolution result requires two sides. Every case I had was resolved, I think, 1 year after the joint litigation was filed. So that's how quickly, people moved on the case. The overview is I try to meet this 5:30 timeline here. I mean, in Cuyahoga, there's not a single jury trial. Most of you who sit in the room don't still know most of the individual stories or facts, or really have a lot of knowledge or didn't see a ton of this play out in front of you. We were able to take something incredibly private, and you have to understand, like, if you worked in a Catholic school, you could get fired if you were participating in IVF. You know what I mean? So we had teachers, we had people who were terrified. We had people whose parents didn't know that they were doing this because they thought they would object for religious reasons. So there were so many issues that overlie this case. But ultimately, I think if I was going down a fifth line to what makes something a great case, is when you're done, you ask yourself, did everybody do right by both parties in the case? And I think that when you look at this case, there's not a doubt in my mind that every single person in this case, whether it be the bench, whether it be the defense, whether it be the plaintiff, whether it be the defendants or the plaintiffs, I believe actually did right by the legal process. And as a result, I think we found the closest thing to justice you can find for anyone. So if there's questions, we'll do questions. But that'll wrap it up.
We are open for questions.
Are there questions from the people who are not here? We don't.
We don't. We are having technical difficulties on that side.
I do want you guys to know that that's the longest I've ever spoken without Rita objecting.
Okay, there's a question over here. My co-director.
So,
Wait for the mic.
So I had heard that this could be the end of university hospitals, that this was so catastrophic and they were going to have to pay so much money that they had no future. And I'm wondering if that played into your thoughts or negotiations, or if that was ever a concern.
So I will say this, and I'm proud to say it on, because I know we're recorded. I am a massive fan of University Hospitals of Cleveland. As you heard Dave, effusively praise University Hospitals of Cleveland in his intro. So I don't think anyone's goal is to do any sort of permanent damage to someone else. But no, once I decided to take a case, the reality of what I had to focus on is what was best for my clients, and then as liaison counsel, everybody else's. I knew they were well represented, and I knew that they were well positioned, and I'm quite happy that based on the resolution you haven't heard those mumblings going forward. So, but I'm a huge fan of the institution. But the reality is once you sign up, the one thing about our business is it's an honest business. I fight for one side for everything I can get, and they fight, you know, in this case for the other side. But if you do it fairly and professionally, it usually comes to a fair place. I think it's a very fair resolution that was reached for everybody, but I don't presume to speak for the defense on that one.
Thank you, Jay. So I have a question. You said early on that there was no precedent for this case in Ohio, right? This was a case of first impression with regard to many of its dimensions. But that I assume that there are precedents in other states, and I wondered how the way this case worked out compared to how the to the precedents in other states, if that's something you can talk about.
So I think that, you know, the wrongful death claim that had some precedent in Ohio, and that got, you know, dismissed at the common pleas level that one of the lawyers filed, and ultimately, you know, reached the Court of Appeals. I think it resolved somewhere along the way. There's differing laws in different states. The challenge that we had in our state is the specific phraseology of the medical malpractice statute. And the specific phraseology of the medical malpractice statute states clearly that if it happens in a medical institution, that it falls under that umbrella. So that was what we struggled with the most, like verbiage-wise, like how do we get around that from a bailment standpoint. But I think irreplaceable property is the closest definition. I would say that if you took all of the case law and things from around the country, it would fall under an irreplaceable property argument of what is an egg or an embryo. I've not seen states where they have individual rights to pursue a case, and that's what you need to pursue a wrongful death case. The embryo or egg would have to have individual rights that are recognized. And so most states, I think, deem them to be irreplaceable, you know, property. But what's interesting is there's actually a marketplace, you know, for them, which is one of the things that, you know, we learned that there is actually monetization of eggs, embryos, and other components.
I have a question I'm a little reluctant to ask because emotionally I'm not happy with it, but when you were in your negotiations and trying to place value on eggs and embryos, did you take into account the chance that the egg or embryo would become a viable fetus and the fact that for many they wouldn't? It's more the emotional hope and aspiration for the child, or the ultimate child rather, than the fact that you actually have an egg that becomes a fetus.
I'll give two answers. One, we took a very scientific approach, and that was some eggs and embryos are frozen at the 3-day mark. Some, you know, embryos are frozen at the 4-day mark or 5-day mark, and they have different biological markers and they get different gradings. So we looked scientifically at what do we think the likelihood for each of these to be successful would be, because we feared certain, you know, legal challenges, you know, on outcome and damages that the defense may argue. They may bring someone in to say this was never going to, more likely than not, become, you know, something more than what it is right now, a hope. From a plaintiff lawyer standpoint, in every meeting that I had with people, the discussions always centered on hope and always centered on what those embryos meant to them or may mean to them and their family going forward. It was, in theory, I've handled larger cases from an economic damage standpoint and things like that, but I don't know if I've handled that volume of more intimate, personal, or spiritual to some level for some people. So yeah, the hope of what they might be and the reality of what they might not be, those were conversations that were had. But, you know, that did factor into some clients' willingness to negotiate. If I'm answering your question, I hope I am. But we looked scientifically and personally for every one of them, and it was honestly like you would really like people so much more if you spent time with these people. They were the nicest people in the world, committed to something, either for themselves or for a future family. They were really incredible people. It was a horrible side blow, for them that they never saw coming. But yeah, hope was the word that drove every one of these people. And that's why that loss of autonomy was, I think, so, crippling for them. I hope I answered that.
We're at the end of our time, but Dean Scharf, do you want to ask a quick question? There's a okay, hang on. A quick microphone over to you.
Jay, in Ohio, is there a limit to the number of causes of action you can argue in the alternative? Did you have to select one as a group?
No, the risk with selecting the cause of action in part was we didn't want to miss one with a shorter statute of limitations. So most of the complaints that were filed included, for lack of a better term, a spray of all potential causes of action. The reality was, had this case proceeded further, there would have become aggressive motion practice between the plaintiff side and the defense over which cause of actions did or did not apply, and I think it would have been summary judgment, type motions, on it. And, I have my opinion, the defense has their opinion, but ultimately it would have been the Honorable Ashley Kilbane's opinion that would have controlled.
Oh, thank you again, Jay. Thank you, Dave, for